given, I mean, it seems like, obviously your view on these cases is that these sorts of bans are not constitutional, right? They're not compatible with the Second Amendment under the Bruin standard. So what's your practical outlook on how these are going to go? I mean, is the Supreme Court going to take a case next session and declare assault weapons unconstitutional? Are they going to wait 10 years? Like, what do you, how do you see things going at this point? Are assault weapons bans on the chopping block now?
I think we're going to find it'll continue to be like it's been so far, with mixed results in the federal district courts. Some will uphold them, some will not, and then it goes up to the courts of appeals, and we may get mixed results from them as well. There's currently a case where, as we speak, a suit against the city of Naperville's Illinois' assault weapons ban was done in the same style as the Delaware case we were talking about. Is like, you come into court, here's your verbal formulation, therefore give me a preliminary injunction. The other side comes in with all this evidence, and the court says, well, I don't, these laws are probably constitutional based on all the evidence we've seen from the other side, and kind of the narrow versus the narrow, but I think correct, but still narrow argument on by the plaintiffs. And then, rather than just saying, okay, fine, we didn't get the preliminary injunction, let's go through discovery and we'll develop more evidence on our side. They ran to the Seventh Circuit and said, give us a preliminary injunction pending appeal. And the Seventh Circuit just simply said no, because again, a preliminary injunction is an extraordinary remedy where you've got to show that, among other things, that you're very likely to win the case on the merits. And so then the next thing, the Naperville plaintiffs now filed in the Supreme Court, U.S. Supreme Court, and said, give us a preliminary injunction pending appeal, which it's not impossible to get one of those, but I think it's quite unlikely. Okay. Because the Supreme Court tries to get cases where everything is fully developed.
Yeah. So you see something like the Fourth Circuit case or the Ninth Circuit case, Miller in California, those being the more likely cases to end up at the Supreme Court eventually?
Well, yeah, the Fourth Circuit case especially. I think it's Bianchi versus Frosch.
Yeah.
Because it's in the Fourth Circuit already. What all the other circuits did was, when the Supreme Court came out with Bruin and granted, vacated, and remanded some cases, the circuit courts in general not only sent those cases back to the U.S. District Court, they took a lot of the other gun control cases that were before them and said, go back to District Court, go redo this case under the Bruin standard, and we'll take a look at it then.
Right, which adds maybe a couple of years to that process.
Yeah, absolutely.
Right? And so we won't hold you to this, but what's your timetable guess as to when an assault weapons ban case is actually going to make it to SCOTUS?
You mean you can, anybody can file a cert petition anytime. So
right, but when do you think they might actually take one
certiorari?
Yeah.
At least a year, maybe more.
Okay. That's still pretty quick in Supreme Court terms, right?
It is, and and definitely the maybe more. I said is doing a lot of work here. I think the more likely thing for them to want to take is these massive resistance to
the Bruin response bills.
Correct. Yeah. New York, and because New York's already had oral argument in the Second Circuit on that, so that's in fairly good shape to move forward. And those are much easier cases because they're not fact dependent. Yeah. If assault weapons, so-called, really were super powerful compared to other firearms, that would inevitably that might change the result. Who knows? But there's at least that dispute going on about them, which is a factual matter. And how often, supposedly, how often are they used for self-defense? That's not something that Heller ever required to be shown. I mean, Heller pointed out that handguns are possessed for self-defense. They didn't get into any data about how often people pull the trigger, but that
Right.
that comes up in the assault weapon cases. But in contrast, to get back to the main point, for the anti-carry bills enacted in New York and New Jersey, and to a lesser extent in Maryland, there's nothing really to argue about factually. They're not arguing it's not about carrying special guns. It's just about whatever handguns happen to be legal in the particular state. And it's really questions, well, where can you ban licensed carry?
Mhm.
And on that, you're going to look at historical analogies. We know all the laws are well known. And so,
And the
an
court just
analogy-
looked at this, right?
yeah, is
So-
or is not convincing. Can you ban them at zoos? Well, Heller said you can ban guns at schools, and government
and-
buildings, and
right.
sensitive places like that. So is a zoo like kind of like a school because it's got a lot of kids? Well, you can argue for or against that,
Mhm.
and you can also look at the history of municipal gun bans in, like, say, Central Park in New York, which
Sure.
had a zoo within it. It's all a very straightforward thing that you can just do. It's
So-
a case you can do on paper with.
So you think those are one of the more likely ones to get taken next? What about,
Yeah.
do you see for instance, the Fifth Circuit case on domestic violence restraining orders? Since that's a federal law that got struck down,
Yeah.
do you think that maybe is even a higher priority for the court?
I'm not sure any of them want to have it as a priority, but you're right. When a federal statute is struck down, that's it's not a guarantee of a cert grant, but it certainly moves the odds in one's favor. The interesting thing is, I mean, it's as a federal law, it's very rarely used. I mean, the laws against gun possession by people under civil restraining orders get a lot of enforcement in state courts, but usually these kinds of cases, I think you might have a couple dozen of them a year at most.
It's a weird case too, because that guy's likely to be convicted of a bunch of different felonies, so he's going to lose his gun rights anyway.
He is very plainly a guy who shouldn't have a gun.
Yeah.
There is no question on that.
So it's kind of strange that this case even got this far without him getting, convicted of some of these crimes. He's being accused of like 5 different felonies for a bunch of different things he's done. Well, that's why the Biden Department of Justice did the cert petition, because they recognize that they don't want to bring mainstream Second Amendment people into before this current Supreme Court, because the court happens to respect the Second Amendment. And this guy's not a model plaintiff, that's for sure.
No,
I think this was a public defender case, right? So
yeah,
he's sort of a wild card situation. Certainly not something the gun rights movement was actively seeking out in this case.
Well, and that's a long-term tension in all kinds of constitutional litigations, because you're right, you have the public defenders who that's their job, is to, as of any criminal defense lawyer, is you zealously represent your client, you do the best you can, and you make whatever arguments you can think of, versus the strategic point of, well, if you're trying to get courts to enforce the Second Amendment, how about showing them some nice people who want to do it? And this goes back to the reason Bob Levy.
Not that it should matter, but it certainly does.
But it does. And that's why the Heller case began with a lot of disagreement about it within the pro-Second Amendment lawyer community. But Bob Levy's and Alan Gura's argument is, look, if we don't do this, then the case is going to be, United States versus so-and-so of some scuzzy defendant. And we'd rather have the Second Amendment presented by decent law-abiding plaintiffs that every reasonable person would agree ought to be able to have a handgun in their home for protection.